Good afternoon, everyone, and welcome back to our video series where we discuss everyday legal topics with TLR Law. TLR Law makes law accessible for the average Canadian and average Winnipegger, which includes creating and updating wills and powers of attorney. It's not easy to plan for your eventual death. Who wants to do that? But doing so does help reduce the burden on your loved ones during a really stressful time. Today, we'll be talking about the functions of a will and a power of attorney, and a little bit more about when to update them and when to create them, and why those two legal documents are so very important. My name's Adam Dooley. I'm your co-host today. I'm here with Philippe Richer, principal lawyer and owner of TLR Law. Philippe, how are you?
Good, Adam.
Fantastic.
How are you?
So you've been busy moving to a new office.
I have, yes, and I hate it. I hate moving. Anybody who's ever moved anything knows how awful it is. But yes, we are moving, and I am excited that we'll be in the new place as of tomorrow, and hopefully ready for business by Thursday, late afternoon, maybe
that's
Friday.
Fantastic. So this is replacing your Pembina location. You're moving your Pembina location to 153 Scurfield, right near Kenaston, which is super convenient for folks in White Ridge, Lindenwoods, Bridgewater, and that whole area.
Yeah. Bridgewater.
Fantastic.
Yeah, right next door to the Ben and Florentine restaurant in that strip mall there's a Dairy Queen. So the sign isn't up yet. We've ordered that, so that should be probably the new year with the supply chain problems that we're having.
Supply chain is killing everybody. So let's, why don't we go straight into our topic here. Can you start off with just defining what a will and a power of attorney are, and maybe just talk about why they're important?
Sure. Most people have heard, or most people know what a will is, so I don't need to spend a lot of time on that. And most people have heard of the power of attorney, but a lot of people are not clear about what a power of attorney is. So the will is the document that you create that gives instructions to your executor how to distribute your assets once you pass away. So typically in a couple, an older couple, a parent or the couple will assign all of their assets to each other. And then if your spouse predeceases you, then usually it'll go to your children. That's usually how it's done. Sorry, I've got Cheryl in the background here, my partner who's on the phone talking, so she's distracting me a bit. This is the joys of working
at home. This is a perfect time to write her out of your will. There you go.
I'm about to. The power of attorney, on the other hand, is a document that you use while you're still alive. So if you lose your competency, you need to have somebody who manages your affairs on your behalf. And if you don't have somebody, then your loved ones who need to do it have to apply to court to be named as committee. It's an expensive process. It's a big burden on those who apply to court. So naming a power of attorney is an easy way that most people can take care of that without necessarily appointing somebody, without that person having to go to court.
So this is a separate document, or is it part of the will?
So it's a separate document. The will is governed by the Wills Act, and the power of attorney is governed by the Power of Attorney Act. So these are completely separate statutes that are provincial statutes. So each one governs its own. Now, functionally, they're very similar. You appoint somebody to manage your affairs for you. One is for once you die, and the other one is while you're still alive. Now, we all know that at some point we'll die, so your executor at some point will engage in his or her functions. Whereas if a power of attorney is more like an insurance policy. If you're competent up until the day you die, then you don't really need your power of attorney. On the other hand, if you lose your competency, either through dementia or Alzheimer's, or even sickness, if you become incompetent by a coma, for example, or even if you maintain your competency, but you have trouble moving around, so you're not able to get out of your house, maybe you're bedridden, power of attorney comes in very handy in those kind of situations.
And what kinds of things does a power of attorney, like what kinds of powers does it grant?
So the power of attorney is it's a very broad document. So in the power of attorney, you appoint somebody to manage your legal affairs. Now that's different from somebody taking care of your personal affairs. Your power of attorney doesn't have the power or shouldn't be rewarded, because there's a compensation provision in a lot of powers of attorney. And if somebody's going out to help you do your shopping, for example, that's not the duty of a power of attorney. That's not a legal action that needs to be done. The power of attorney is somebody to take care of your legal affairs. So your legal affairs include doing your income tax returns every year, your banking. So if you have to sign checks or write checks or pay accounts, those kind of things, that's a legal requirement. If you have to execute any documents, either for your pension or insurance, then your power of attorney can do that. If you want to sell your items, it could be real estate, but it could be personal items like your car. You need a power of attorney to do those things if you're unable to do it. So there are a number of powers, and when we draft powers of attorney, there's probably 7 pages of specific powers that we enumerate in the power of attorney.
And one of the things I've always been curious about is how does a power of attorney come into effect? Like, it's triggered by something or someone. Can you explain that process a little bit? I'm sure it's different for every case, but.
Yeah, so that's an interesting question, and it's kind of hard to wrap your head around at times. A lot of people will ask me, well, who decides when I'm incompetent? The decision doesn't need to be made. So when you become incompetent at law, you're incompetent. So competency, there's a test for competency, and we'll probably talk about that in a couple of minutes. But if you're competent, you know what you're doing, there's no problem. But if you start suffering from Alzheimer's, and this is a big problem actually for people who suffer from dementia and Alzheimer's, because you can be incompetent for a period of time and then be competent again. So if you know anybody who's suffered from Alzheimer's, for example, you'll know that they have good days and bad days. They have more good days at the beginning of Alzheimer's, and as it progresses, the good days become fewer and fewer. And that the time frame that you're with it and lucid becomes shorter and shorter. Well, during those moments where you're lucid and you know what's going on, you're competent. In those moments where you're confused and you don't know who people are and you don't know where you are, you're incompetent. You either are or you aren't. Nobody says you're competent or incompetent. And that's kind of confusing for people, because they say, well, how do I know? It's up to your power of attorney at that point to step in and start acting for you when you can no longer do it. If there are problems with how somebody manages a power of attorney and it goes to court at a later date because somebody's saying, you know what, that attorney did not take care of my grandmother, they took all the money, they weren't supposed to, she wasn't incompetent, then it's up to a judge to determine with evidence that's supplied by people who knew the person at the time, whether or not the person was competent or incompetent. It becomes an evidentiary issue that has to be proved at a later date. But that's for dealing with a problem in the future. A power of attorney is meant to help you manage your affairs today. So when you're incompetent, you just become incompetent. Now, there are 2 types of powers of attorney when we talk about estate planning. There's the enduring power of attorney, which takes effect the day you sign it. And the people that you appoint can act as your attorney during that period of time. And then when you become, they can act on your behalf as soon as you sign it, but they owe accounts to you. If you are competent, you know what's going on, they report to you. And if you're not happy with that attorney, you can say, hey, listen, son or nephew or Joe, I'm firing you. You're doing a terrible job. You're messing around in my business. Get out of my accounts. Go home. I'm pulling the plug. Right. You're no longer doing this. So the accounts are to you, and that's who that person reports to. They're your administrative assistant, if you like. If you lose your competency, that person goes from being responsible to you to becoming responsible for you. And in the eyes of the law, you're elevated now all of a sudden as a trustee, which is the highest responsibility that the law imposes on somebody. And courts, judges get very interested and concerned when somebody's acting as a trustee, because they're in charge of somebody who's vulnerable now, who can no longer take care of themselves. So the court will hold those people's feet really close to the fire. And they'll say, well, okay, let's really take a look at the actions you've taken now, and are those responsible actions? And if they're not responsible, I'm going to make an order against you that you're going to have to repay all that money to the estate or to the incompetent person. You can be removed as a power of attorney by the court at that point and placed either in the public guardian and trustee hands or somebody else who comes forward
so who's some pretty serious responsibilities.
So It's a very serious. In fact, once you engage your responsibilities as a power of attorney, and the person is incompetent, becomes vulnerable, and you're responsible for them, you can only get out of. You can't resign unless you have court permission. So you have to, if you want to stop, because you're no longer capable yourself of doing it, or the burden is too much, you have to go to court and apply in front of a judge to be removed. And they'll probably ask for a passing of accounts, because they're going to want to see how you manage those affairs on behalf of the incompetent person.
So what's the trigger mechanism? So I just want to dwell on this a little bit more. Let's say I'm power of attorney for an uncle who is, I think, unable to look after his affairs. Do I just need to show up at the bank with this document and say I'm acting for Uncle Joe? Like what does that look like? And what if Joe doesn't want me to do that?
Right. So good question, and I guess I didn't finish explaining what the second type of power of attorney is. So let me explain that first, and then remind me to get to the answer to this question. So the second power of attorney type that's available is a springing power of attorney. And the springing is there's a certain action that occurs that all of a sudden springs the power of attorney into action. So until that event occurs, the person who's appointed attorney cannot do anything on behalf of the individual. Now, most of the time, that springing action will be a letter from a doctor that says the person's incompetent. But you can make it whatever you want. You can make it a family member who declares that you're incompetent. You can make it a family friend who declares you're incompetent. So if you're under a springing power of attorney, you have to wait for this type of document to show up, this springing action to be engaged for you to start acting on behalf of the person. Whereas in the enduring power of attorney, you have the power the moment that the donor signs the power of attorney. You have the power is vested in you at that point to start acting. While the person's competent, they can say, hey, stop doing that. And then you have to stop, or you can be removed. But once you become incompetent, that attorney is your attorney, and they can do exactly as you said. They take their document to the bank, and most power of attorneys look very similar. And every now and then we'll get a call from a bank asking us if we drafted the power of attorney on behalf of so-and-so, and we'll say yes, and they'll be satisfied that the person's the power of attorney. But the document itself is a legal document. You don't need a lawyer to approve it. Once you have the power of attorney and it meets the requirements of the Act, meaning it's been witnessed by there's a series of witnesses that are allowed to witness the signature of a donor in a power of attorney. So as long as it meets the requirements of the Act, it's a legal document. It doesn't need court approval.
Okay, let's double back to my Uncle Joe. What happens?
Right. So your Uncle Joe, if your Uncle Joe appoints you, Adam, as his power of attorney, and it's an enduring power of attorney, as soon as the ink is on there, it doesn't even have to be dry, you now have the power to do all of those things. You can go into his bank accounts, you can sell his house, you can mortgage his house, you can do his tax returns, you can do all those things.
Acting as if he were,
if he's competent,
him, right?
Yeah. Now, it's important to remember that your Uncle Joe does not lose his ability to make decisions when he signs that power of attorney. You're not giving over your decision-making power to somebody else. What you're doing is you're appointing, while you're competent, you're appointing somebody who's your assistant. And then once you lose your competency, you don't. It's not that you gave your power to make decisions to somebody else. You just lost the ability to make decisions, and then your power of attorney can continue on now as a trustee on your behalf.
That makes sense. Okay, and then if it's a springing power of attorney and Joe doesn't think that he's incompetent, challenges this, that's probably a scenario that happens frequently, I imagine, or occasionally.
No, if it's a springing power of attorney, then you can't act until that event is sprung. Now, typically that's a doctor's note, and there's not a doctor in the world who's going to declare somebody incompetent at the first signs of Alzheimer's. They're going to wait until the person really truly is incompetent. There are no more lucid periods, and decisions can no longer be made, and they'll wait till that. And that's why I'm not a huge fan of springing powers of attorney. I find them to be to lack flexibility, because it could be a long road before that action triggers the power of attorney And in that time where you are in and out of competency, you don't have anybody to help you manage your
Okay,
affairs.
Janice, I'm going to go to the last question if you want to pull it up. And that's should I put any restrictions, or should anybody who's creating a power of attorney, should you put restrictions on that attorney in the power of attorney document?
I mean, you can. The whole purpose of a power of attorney is to have somebody that you trust, that's close to you, to manage your affairs. If you have to start restricting that person, then the element of trust that you wanted there to begin with,
Right.
there's something wrong with it. And so that doesn't happen often. This is why I don't like springing powers of attorney, but there are certain situations where a springing power of attorney is more appropriate. And typically where there's some trust issues, and that's kind of, it's bad. Because it's terrible to see somebody in a situation where they don't really trust anyone to take care of their affairs on their behalf. But it can happen, and there could be certain circumstances where that's appropriate. I'm not going to say that it would never be appropriate. But generally speaking, I prefer the enduring general powers of attorney. You do give up some control over that, because now all of a sudden you have somebody who can muck around in your business. But hopefully that person that you appointed as your attorney is somebody close to you that you can trust, that's not going to go around and mess things up for you.
What kind of qualities,
not
including like their location, who they are, what kind of qualities should we be looking for in an attorney to look after your estate?
Well, it should be somebody you trust implicitly, right? If somebody has a gambling problem or an addiction problem, you shouldn't probably be appointing them as your attorney.
Not high on the choice list, no.
Not high on the list, no. You could love them dearly, right? As we all love members of our family, and sometimes that we have family members that struggle with addiction. So that's a terrible thing to live with. But that, from a managing your own affairs point of view, appointing that person as your attorney is probably a really bad idea. It used to be in the old days, you wanted somebody close to you. Now that's not as relevant anymore, because everything can be done online. Your banking can be done online. I mean, there might be some situations where you do need to show up somewhere, but now even, selling a house, it used to be you had to be in person in front of a lawyer prior to the pandemic, and that's all changed now. We can all do remote witnessing. So even meeting a lawyer for selling a house, for example, which is a big transaction for somebody, you can do that remotely. So proximity can be useful, but it's not as useful as it used to be. And then you want somebody, obviously the person needs to be 18 years old or older. You can't appoint somebody who's 17. I've had clients who tried to, we said, well, I'll appoint my kids, I'm fine now. And then, by the time their powers are engaged, they'll be adults. Well, if you appoint somebody who's under the age of 18, that disqualifies them at the time of the appointment, then they're never qualified to become attorneys in the future. So they can't age into it, so to speak. So it's void ab initio, which is Latin says that from the beginning. In law, we love these Latin maxims.
I know you do, and we still love you for it for some reason. So let's just switch to the will. So you're right, most people know what a will is, but let's just review who needs a will and what you need to be in place to make a will valid and all of those good things.
Right. So maybe I'll start off with if you die without a will. If you die without a will, there is a misconception. There are people who believe the province or the federal government or the state ends up getting your assets. That is incorrect. That is not the case. If you have nobody in your life related to that they can track down, the very last person left standing is the state. So it is possible that the state will end up inheriting your assets, but it's highly unlikely. I've never seen that happen. Typically there's a nephew or a cousin or somebody in the woodwork that comes out that you can that inherits. So if you die without a will, you die intestate. That's the term that's used, and there's funnily enough a law to address that, and very originally it's called the Intestate Succession Act.
I wonder how they come up with these names.
I know these legal drafters at the province are just sources of intense creativity. So that's what happens if you die without a will. If you die but if you want to give your stuff to so for example, if you want to give if you get married and it's your first marriage and you have children and you grow up and you have this nuclear family and you never remarry and your children become adults. If you die without a will, or if you die with a will and you want everything to go to your spouse and then to your kids, if your spouse predeceases you, the same thing will happen. It gets more complicated when people get remarried and they have children from previous relationships. In those kind of situations, then the Intestate Succession Act is pretty tricky, and it distributes things not the way you would expect them to be distributed. So it's really important at that point to talk to a lawyer to get a will drafted. Now, you can draft your own will, and we'll talk about that maybe right now or in a few minutes. It's called a holograph will. But I would not recommend drafting a holograph will in a reconstituted family situation, because there are competing interests there. There are competing legal interests, meaning they overlap each other, and one can cancel out the other. So it's very tricky. It's very complicated. There is no perfect solution. You have to make a compromise at some point when you do these things. So definitely something you want to talk to a lawyer about, because your assets can be distributed very differently than you want them to be, and you can cause all kinds of problems with the beneficiaries now being mad at each other and being mad at your new spouse and being mad at his or her children. All kinds of fights erupt over this, and families get destroyed. So it's really, really important, and it's incredibly sad. I mean, I have cases that we're dealing with right now where that is the case, where families are torn apart because it wasn't communicated properly and it wasn't managed
So a holograph
properly.
will in Manitoba, now
So
I know a lot of people think they can just do an online will kit or something like that, or type something out and sign it, but those aren't the rules in Manitoba, are they?
No, actually, that's worse. If you want to do a holograph will, it has to be in your own handwriting. It has to be dated at the top, and it has to be signed at the bottom. And you cannot add anything after your signature. If it's added after your signature, it's going to be discounted. So it has to be in the body, and it has to be bracketed by the date at the top and your signature on the bottom in your own handwriting. If you type it out, now all of a sudden you need to comply with the requirements of the Wills Act, which mean you need 2 independent witnesses, you need an affidavit, blah, 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 blah. So if you're going to do a holograph will, you can do a holograph will. Just do it in your own handwriting. And make sure there's somebody around afterward who can recognize your handwriting, that can sign an affidavit that says, yeah, I recognize that person's handwriting.
You know, if you're not a lawyer, you're probably going to be imprecise in your language. And I mean, to me, you're just asking for trouble if you're trying to describe what you want to done with your estate, and you're not asking for a professional to guide you. And do you want to just address that?
Yeah, so let me address it this way, and it's going to be a little crass, but on the files that I've charged the most money is because people have done a holograph will and messed it up, essentially. So what ends up, I mean, from a legal point of view, these things are incredibly interesting because it creates all kinds of problems, and we need to do research and we need to figure that out. And then we end up billing for our time, right? Because that's what we sell. I don't sell cars. I don't manufacture cars. I don't make widgets. I don't serve food. You know, it's our time that
I think the last thing anybody should desire
and
is
if you have a holograph,
going to be a test case in a legal college somewhere. You don't want your name to be reviewed as what not to do by a future legal class.
The worst thing you can hear from your lawyer is, wow, that's very interesting. because from a legal point of view, it's interesting because it's conflicting situation, and you wonder how, and that means you're going to have to figure it out. And if we have to figure it out, that means reading a lot of case law and reading a lot of statutes and talking to our colleagues and working through arguments, and you know, a lot of time goes into that. It is incredibly interesting work from a professional point of view. But those are billable hours, and the client ends up paying for that. And at the end of the day, we're not doing anybody a service. So the testator who thinks they're saving, you know, $500 by writing their own will, holograph will, especially in complicated situations, it's pay me now or pay me later, and they're going to pay a lot more later. So all you're doing is you're passing the buck down the road too. And really, you know what? I don't have a lot of time for testators who do that, because what they end up doing is they end up burdening their family, right? And to me, that's incredibly selfish. Right? You want to save $500 because you don't want to pay a lawyer to do your will. You draft a will that doesn't work, and then you destroy your family because of that. I've seen that happen, and quite frankly, I don't have any compassion for those people afterwards. I'm like, well, too bad, so sad. It's kind of, I feel bad for the people who are left standing, who have to clean up a mess made by somebody who was too selfish to go to see a lawyer over this.
Can you give some broad guidelines about what time in a person's life should they typically be getting or drafting a will? What time of life should they be typically drafting a power of attorney?
Yeah, good question. We recommend doing the power of attorney at the same time that you do the will. Because you never know when the power of attorney will need to happen. And I always talk about those two documents like a relay race, right? The power of attorney is good while you're alive, and then on the moment that you die, the baton gets passed to the executor. It could be the same person. It doesn't have to be. It could be the same person, but the baton gets passed to the will, and then all of a sudden the will now comes into effect. So if you're young and you have some assets, and you're not married, and maybe you want to give your stuff to your parents, well, the Intestate Succession Act will probably do that for you. But if you wanted to give it, equally to your siblings, for example, then you probably want to do a will. But quite frankly, most young people, even if they do start accumulating assets, don't really think about a will, and I don't blame them. If I was 25 years old and had $50,000 in the bank, the last thing in the world I'd be thinking about is doing a will. If you have kids, it's probably a good idea to start thinking about that. You're starting a family. You can talk about in your will who's going to take care of your children should something happen to the both of you. It's not binding, but it gets you thinking about that, and it's probably a good precaution, because while it's unlikely to happen, it has happened. I remember when I was a younger man in the military, it was a tragic situation. There was a fellow I worked with who was retired from the military, who was working as a civilian radio technician, and his daughter or son, I think, and daughter-in-law died in a car crash in Thompson with two little children in the back seat. The children survived, the two front, so he's 70 years old, and he's raising two little girls. This was, 20, 30 years ago, so it's a long time ago. But, those tragic situations do happen from time to time. We're not immune to it. You look at that MLA who just passed away in Thompson. It's incredibly sad. So if you have children, it's probably a good idea to start thinking about that. And as you get older and you accumulate assets, then for sure you want to do that, especially if you want to maybe give some of your money to a specific cause, for example, the church, or your church that you go to, or the Humane Society, or cancer care. Your wishes won't be followed unless those are in a will. And you want, whenever there's a life change, if you're getting married or if you're getting divorced, a marriage revokes a will, but divorce does not revoke a will.
So that's when you want to update.
If you're getting divorced and you have a will,
those big life change moments, right?
Correct. So if you get married, and you have a will that already exists, well, marriage revokes that will. You're going to have to redo one. If you get divorced, then you for sure want to get one redone, because the divorce doesn't automatically revoke a will, and that can be
so
really
I know
problematic.
You've got an interesting example of not just, this isn't a will example, but it is sort of related, that you don't need to just update your will, you also have to update your beneficiaries on your RRSPs and other similar documents, correct? Like life insurance policies and that sort of thing.
Right. So there are a number of financial products out there that kind of don't fall into the will necessarily. When you die away, they're more considered a gift on your last breath while you're still alive. So inter vivos, again, Latin for, because that's such a useful language these days. So if you die, what happens is if you name a beneficiary in your life insurance policy, then on your last breath, you give that money
Right.
to your beneficiary. So if you have and if it goes to the beneficiary, it goes tax-free to the beneficiary, right? So that's a huge advantage for life insurance. So you want to make sure that all of your beneficiaries are lined up with your intentions in your will, and you have to be careful with that because you may end up in a situation that is unintended. And the example that I want to give is a case that happened recently in Nova Scotia. It was in the news. I wrote an article about it on my website. It was in the news last spring, I think, and it was a fellow who died and gave everything to his spouse in his will. Now, his spouse and his mom, by the sounds of it, didn't get along. The man had, before he was married, had RSPs and had designated his mother as his beneficiary. He never updated that. So when he died, most of his estate, most of his value was in this $800,000 in RSPs, or 500, I can't remember, but it was hundreds of thousands of dollars in RSPs. And there was very little left outside of the RSPs in terms of value to give to his spouse. So his spouse ended up not getting a whole lot, and his mother ended up getting a huge amount. On top of that, when RSPs are protected, are tax-free until they come out, right? So if you invest in an RSP, you put that money in RSP, you deduct that from your income because they say, we're not going to tax you right now on that. We're going to tax you when you take it out. So once you start taking out your RSPs, that supplements your income, and then you pay tax on that. Well, when you die, Revenue Canada has a deemed disposition rule that says that when you die, you're deemed to have sold everything. If you're married and you designate your spouse as your beneficiary, then those usually roll over without any tax consequences. But that's the only exception. If it goes to anybody else, your parents or your children, then it's deemed cashed in. So if you have $500,000 in your RSPs and you die and you don't have a spouse anymore, and it goes to your children, or in this case, your mom, that money goes to them, but the estate bears the burden of paying the tax on that. So in your last year, your income, you're going to have to declare an income of $500,000. Guess how much tax you're going to be paying on that? Probably close to $250,000, $260,000, $270,000. And it's not mom that's going to have to pay for that. They'll only go after mom if there's nothing left in the estate. So these are situations where you really have to be careful, and why it's important that you line up these things. Now, that was a case in Nova Scotia. On the facts of the case, I'm not sure it would have happened that way here in Manitoba because our laws are different than they are in the Maritimes. But nevertheless, there are the moral of that story is make sure your things line up properly, because if you try to be clever in how you do this, I'm going to give the cabin to this person and my RSPs to this person. You're gonna end up with a mess on your hands, or not you, but your estate's going to end up with a mess on your hands where you thought you were giving things equally. And in fact, what you're doing is you're giving the cabin to one kid, and then the other kid paying, has all the RSPs to pay for, and that type of thing. So, and the taxes.
We're just about coming to the end here, Philippe, but I just want to give you a plug, or give you the opportunity to plug your services. You do offer some emergency end-of-life consultations if somebody needs a will in a hurry or needs to update their will. You are able to accommodate people even with bedside visits if it's possible during a pandemic, right?
I've managed to, in the pandemic, to get into the hospitals. Typically, they'll allow us in to take instructions for wills and powers of attorney. So we do offer that service. So we'll attend the hospital. We'll attend the palliative care facility if we have to take instructions, to draft wills, and so we.
Is there anything about wills updating, creating, or powers of attorney that we've kind of flogged this horse to death, and I don't know if the horse has a will himself, but is there anything else that we should touch on before we go?
Yeah, we should probably just briefly talk about, you talked earlier about when is a good time to make a will. I've had a few people come into the office bringing their mother or father who's starting to show signs of Alzheimer's or dementia, and they don't have a will, and they want us to put a will together for them. Those can be very tricky situations because one of the obligations that we have is to ensure that the person is competent. Now, earlier I talked about a springing power of attorney. One of the springing functions that we often see is a doctor's note that says that the person is incompetent. But incompetency at law is a legal test. It's not a medical test. And the Supreme Court has been very clear about this to us lawyers, practitioners, about what needs to happen. And there are certain elements that we have to be satisfied exist before we'll draft a will for somebody. And those things are, we have to make sure that the person understands the effect of a will. So if they're, if you're calling me to do a will, then usually why you're doing that. But if it's your son that's calling me for your will and you show up and I ask you, why am I here? And you say, well, I'm not really sure why you're here, then we've got a problem. You have to understand, you have to have you have to know the relationship that you have with the people that you're giving your stuff to. So if you don't recognize your daughter, or you can't remember how many kids you have, then that's a problem for us. And you have to understand what you own and the value of that. So I've had, I've had people that I knew were millionaires, and they were so far gone that, they were talking about properties they owned that were worth, $5,000. So if we're not satisfied that the person is competent, we cannot draft a will or power of attorney for them. So if you have a family member that is getting older and they're stubborn and they don't want to do it, it's really important that you get them in front of a lawyer to at least talk about these things, because sometimes it's too late, and it's really quite sad when it's too late. Like, people come into it's confusing for the older person, because they're frustrated because they don't know why they're there. And they know a little bit, but they don't know enough, and it creates a lot of anxiety for them. It's a very difficult process for people who are starting to lose their mind, to be constantly reminded that they're losing their mind. And when you're talking to a lawyer and they're asking you questions about what you have, it's very embarrassing for them to have to say, I don't know, and they try to cover up. And it's a very challenging situation. It happens quite regularly in our practice, because we do quite a few wills and powers of attorney. And it's very difficult. So bringing your parent in once they've started losing their competency is going to be very stressful for them, to the point of being traumatic. I've had people scream, and it's terrible for the family that's there to support them too, because now they're dealing with a parent who's clearly distressed, and it's difficult all around. So it's really important, if anybody watches this and you're older and you think you might be, and you have Alzheimer's in the family, don't put this on your children. Don't put this on your spouse.
Just get it done.
Put on your big boy pants, and get it done. And don't cheap out. Don't, especially have a complicated situation. Pay the money. Don't pay it to me. I don't care. Go see another lawyer.
Get it done. Yeah.
But do not burden your family with this. If you do that, you have no sympathy from me. You're selfish. I've got all kinds of names.
Well, I'm sure all the people in our audience don't fit that bill, but thank you for the warning. Thank you so much for sharing your knowledge today, Philippe. I really appreciate it. That was an excellent discussion on wills and powers of attorney. To our viewers, sorry, go ahead.
It started off great with Cheryl interrupting me while she was on the phone.
Well, she's already out of the will, so it doesn't matter.
Right.
To our viewers, thanks very much for watching. Please like and share this live stream, and like our TLR Law Facebook or Instagram pages if you haven't already. We post regularly on those channels. But if you'd rather just check out Philippe's blog, he regularly publishes very interesting things, including examples like that RRSP beneficiary case. I also want to remind people that, and that's at tlrlaw.ca. I also want to remind people that TLR Law does have 3 locations: at the foot of the Provencher Bridge in St. Boniface, at Sargent Avenue and Wall Street, and the new location, which is the new location for the Pembina office. It has moved to 153 Scurfield, near the corner of Scurfield and Kenaston. Thank you again. Merry Christmas, everyone. Merry Christmas to you, Philippe.
Thanks, Adam. I just wanted to quickly say, so our Sargent and Wall location is the State Attorneys of Manitoba. It's not the TLR Law. It's a different name. It's the same organization, but that was a place that existed Caroline Kramer retired, and we took over that practice, and we kept the name. So if you're looking for estate work, there's certainly that's an option. But we offer those services in our other
exactly right,
locations as
and
well.
it just shows your expertise, your firm's expertise in estates and wills. So thank you for pointing that out. That's absolutely true. That's it for today. Thanks again, Philippe. Happy holidays, everyone.